So, hello everybody, and welcome back to Big IDs on the go. Very excited to talk about something that's very topical in the privacy world right now, which is the Brown versus Google decision, Schrems II, and what that means for the data privacy industry and for organizations that are thinking of moving data between Europe and the U.S. So with me, very excited to have a guest, Matt Getz, who's a lawyer in London at Boies Schiller Flexner. Maybe just to kick things off, Matt, I'd love you to maybe talk a little bit about yourself and how you ended up working in the data privacy landscape. Maybe you could just introduce yourself very quickly.
I'd be happy to, Dimitri. Very nice to meet you. Some of you might recognize, I'm from South Africa, but I'm an American lawyer, and I did law school in the United States. I've been living and working around the world for much of my life. I first got into data and data privacy and data protection actually through the work I do in anti-corruption investigations. Some years ago, I was working on what was then the largest investigation ever into Siemens. And we had to work out how to get data from Europe, especially from Germany, to the DOJ, and to do it in a way that was compliant. And there I was, a young American lawyer, didn't have any real idea about data privacy and data protection. And we worked together with the company and with the various authorities and regulators to get the data from Europe to the US. And that led to an interest in data protection and data privacy. And I've been working on that along with the corruption and the investigations and the litigation ever since then. So data has been a continued part of my job, helping companies both on the compliance and advisory side, working out incident response plans, working out what to do with their data, and, defending and prosecuting companies and individuals for data breaches, and issues of personal data protection in the UK and elsewhere.
So I know that in late 2017, you started working with the U.S. Department of Commerce and the European Commission. Was it as part of this broader initiative around Siemens and trying to repatriate the data?
No, that was actually part of the Privacy Shield, because one of the ways in which it was hoped that European data subjects would be protected would be through the use of arbitrators, selected to arbitrate on what is happening to their data in the United States. And a few of us were selected. I was chosen as one because I had experience in European data laws, US data laws, and some in arbitration. And we were there to, decide on these disputes. Interestingly, there were very few arose over the last few years. And in fact, the program I felt worked quite well from the point of view of data subjects. There weren't a lot of big issues, which is why I think the Schrems II decision is really so interesting in a lot of ways.
So let's talk a little bit about Schrems II. So, maybe you could, first of all, tell us whether you were surprised by it, but maybe talk a little bit about what you think happens from here.
Okay. Was I surprised? Well, yes and no. There have been a lot of knives out for the data privacy program, for the Privacy Shield program, kind of from the moment that it started. Some NGOs were against it. The Irish courts that it went through were not very happy about it. Of course, Mr. Schrems was opposed to it. The Advocate General didn't give a good opinion. On the other hand, the European Commission have continued to give it glowing reports. They said things were going very well. So that was, so in that sense, striking down the Privacy Shield was probably not such a big surprise. The fact that they kept the standard contractual clauses in place, not such a surprise, because that's been a part of EU data law for a long time. But I think what they said about what the data controllers and exporters have to do relating to the standard contractual clauses, I think that was a bit of a surprise because, as you've probably seen, nobody really knows what that means and what they're supposed to do now. There has been, from all of the authorities, from the European Data Protection Supervisory Board and from various data protection authorities, a bit of a I don't know if I want to say it, but a bit of a headless chicken reaction. You know, none of them really seemed prepared for it. You know, it's not like they were sitting there saying, well, this is what you need to do now. They've all said, oh, we welcome the decision and we're thinking about it and we're going to come back to you and tell you what you need to do. So that says to me that they were surprised as well, you know, didn't have contingency plans in place.
So as somebody that's been in this problem area predating the first decision in Privacy Shield, you know, what is a company to do while the DPAs are figuring it out? How is a company supposed to act?
Well, I think your best thing to do would be to be based in the UK, because at least there, at least there, the Information Commissioner's Office has actually said, you know, we consider that you can still keep using the Privacy Shield, which I don't know if any of their counterparts have. I know they haven't said that in France or Germany or elsewhere. Look, I think there's obviously going to be, while on the one hand, the decision has immediate effect, there will be a lot of latitude and leeway in terms of enforcement. And I think the authorities are going to let people start working out what to do in the meantime and not take immediate action. I think the very first thing to do for anybody who doesn't is to, you know, to do an audit, work out exactly what data it is that you've been sending across using Privacy Shield, and work out if there are other ways that you can send it across, work out if there are what other measures you can use, you know, if anonymization can work with things, if pseudonymization can work, and start working out as to whether some of the data can stay in the EU. I mean, frankly, if we take this through to its ultimate effect, its bulk transfers of data to the United States are going to get really, really difficult.
And so I know that there was some talk and some guidance around supplementary measures. So is that what you're describing here in terms of the audit and in terms of just understanding what you have and then just resigning yourself that it's going to be difficult?
Well, I think that's part of it. You know, those supplementary measures. I mean, I think regular audit, and it's not just a one-off audit. I think there needs to be regular audits and reviews by companies, by controllers and exporters of exactly what's happening with their data, where it is, you know, if there's any governmental intrusion, so that they can say to the authorities, well, we're checking in these particular instances, the data is kept safe, and we are able to repatriate it if we need to. Because I think a lot of people don't really have repatriation schemes in place if necessary. I think they need to make sure that anything necessary, that it's all being sent across, transferred for necessary reasons. And I think some might need to start, well, not some, I think all should start thinking whether they can take advantage of the other derogations for international transfers in Article 49 of the GDPR. You know, to the extent that it's, you know, that it's necessary for protection of data subjects, that's necessary for legal claims, or that it's necessary for, you know, for fulfilling contracts and that. Those aren't really designed for bulk transfers, which means that people are going to need to look more closely and take a bit more time and more resource in assessing what data is going across.
Do you think this will usher in a new period where enterprises are going to be responsible for continuously auditing and monitoring what data they have by the residency of the data subject, so that they always know what that is and they get alerted to any cross-border transfers, whether it's inside of the EU or obviously between the US and the EU or going to other third-party countries?
Well, I mean, I think maybe the question is obviously, you know, which you would know better than I, is to what extent that kind of thing is feasible. You know, the kind of tracking and the knowledge that you need to have everything, you know, seems to me would require a great deal of human and computing resource. But I think we are moving towards that. I mean, I'd also say one thing. Look, I don't really. You might have heard this. I mean, we're talking practically. And not theoretically, I don't really agree with a lot of things of this decision. I think there are problems. But if you take this decision to its logical conclusions, it seems to me that almost any large-scale transfers from the EU to a country that does not have an adequacy decision, and remember, there are only about, I don't know, 12 or 30, countries that have adequacy decisions. Any one of them seems to me would probably be in breach of the rules that the ECJ has set down. It just so happens that everybody's most interested in the United States, but what about any data that goes to South America or to China or to India or to Russia or to Southeast Asia? It's a smaller amount perhaps, but people need to be concerned about that also.
Yeah, so, not that I normally plug our company, but it is possible from a computational standpoint. That is what companies like BigID do, is monitor data by the residency of the data subjects and understand what gets transferred and what. Obviously not the reason we built the company, but it is interesting that with this kind of, whether it's the EU and the rest of the world, or even this kind of shift around data residency. I am curious about your take on data residency even beyond the EU. Do you just think that there's going to be more data sovereignty as just part of the natural evolution of this kind of, not really a free trade, but a counterparty exchange of data?
Look, it's like a lot of the world. Things are pulling in two opposite directions. On the one hand, the data wants to move around. It's so easy to move data, easier than ever before. But I think you do have the EU and elsewhere, California is adding in other places, which makes for a lot of pressure to keep the data where it is, where it was from in the first place. If you need additional reasons to transfer it to somewhere else. And it's kind of like, free trade, and what's happened over the last years, where the EU has created this massive block where it's very easy to trade inside there, but trade between the EU and elsewhere sometimes becomes much more difficult. I do think this now leads to a clash between the laws and technology, because it is so easy for data to move about, and there is so much of it. And it's getting to a point where, the courts and some of the laws consider that you need to have this absolute handle on all the data. And there are going to be a lot of companies who just can't manage that, probably because they don't put resources into it.
And well, there's a corollary, which is a lot of companies have shifted to the cloud. I am curious about what you think the responsibility is of all the cloud providers where, that are now hosting a lot of this data, and may not be providing the adequate visibility or accountability in terms of both whose data and the location of where the data actually resides.
Yeah, I think they're probably the most important ones. We've had statements from a few of them saying that they think that they can continue, taking the data, putting the data in servers in the US and elsewhere. That's not fully supported as far as I can see. I think what they're going to have to do, what they are doing already, is engage in very deep conversations and deep discussions with their supervisory authority in the EU, whichever one that is. If they're going to be dealing with the CNIL or the ICO or regional German authorities, they're going to have to work something out, because their customers are starting to say to them, "What are you doing? You're our processor, we're the controller. We actually want you to repatriate the data. We need to know where it is, and we need to know that you're putting together these adequate, these supplementary measures." And I'm not sure that they're always going to be able to have the answers for that. Okay. Especially because one of the big things that that the ECJ was concerned about, and that the others are concerned about, are US surveillance activities. And those laws aren't going to change. I mean, the striking thing, obviously, about Schrems II is that it doesn't actually refer to any case where a data subject has actually been harmed, where a data subject's data has actually been taken by the NSA or some other spy agency without their knowledge. It's all the risk of it based on the laws, and that's not going to change.
Well, look, I think it's going to be very interesting, and certainly it adds a little bit of spice to, I think, the discussions in the privacy world among the professionals, whether DPOs or CPOs. It'll be, so we'll see, I guess, how the next few months evolve amidst COVID and everything else. I want to touch on a couple of other things before I let you go. I know that your firm was involved in a very important recent decision in terms of finding Google, $5 billion in terms of violation of CCPA. I don't know how much of that you could talk to or speak to.
Well, to be clear, no, I think we were involved in something, but I think right now what we're involved in is a class action suit that we brought against Google in California.
Okay.
And that suit, and I can talk a bit about it. It's public. It's been released. It's under the name Brown v. Google, and it's really interesting. It relates to Google's data processing activities when people browse in private mode. In particular, Google Incognito, but also browsing in private mode elsewhere. And basically, it's about the activities of Google Analytics and Google Ad Manager. And the thesis of our case, which I think is more than a thesis, is that when you browse incognito through Google, or when you browse otherwise on a Google browser, they state that your data is not really being tracked. It's very interesting. You open a Google Incognito window, it says, these people will not see your data and these people will see your data. And the people who may see your data are, your school or employer, the websites you visit, and one other. It doesn't say Google. But because of the way Google Analytics and Google Ad Manager work, because they are embedded on the websites of more than 70% of all publishers, and in fact, I think the number is somewhat greater than that, if while you're browsing in private, you visit a page that has Google Analytics or Google Ad Manager on it, which, New York Times, Washington Post, BuzzFeed, Reddit, they're all over the place, then Google is actually collecting and processing and storing users' data. And it's keeping that data and it's doing things with it, even though people think that Google is not taking the data. We think that this is a violation of the California privacy laws and of California's right to privacy under the Constitution, and in fact we allege that it's a violation of the federal wiretap laws. The big point is that just about the headline is just about everybody who's been browsing privately and thinks that they are browsing privately actually hasn't been, because Google has been collecting and using and storing their data.
And so what's the status of the case right now?
Oh, it's very early days. We just filed the complaint a couple of weeks ago.
Okay.
It's a class action complaint, so it's new.
Yeah.
Google hasn't had to respond yet. It's a class action, so I'm sure there will be a lot of action with Google, I guess, trying to decertify the class, and putting up whatever defenses they have. So, but we think this is a real issue.
And what does it mean, you think? So if you're successful a couple of years from now with this class action, what's the implications to both Google, but some of these other companies, these kind of internet giants that are actually in front of Congress today?
I think the implication is that people are going to have to, if they walk the walk, they're going to have to talk the talk. That the companies are either they're going to have to do what they say in their privacy policies and actually be a lot more careful with people's data. Because they're making a large windfall from it. I think Google would have to change the way that its analytics and its ad manager programs work, as it's had to do with some of its other programs over time. I think it will lead to a much different way of processing and storing people's data, and they're not going to take as much as they have up to now.
Okay. Well, interesting times, and it sounds like you're right at the heart of the interesting times.
It's a great time to be working in this field. It really is.
So, Matt, I just want to thank you very much for taking the time to join us today and sharing a little bit about both the Brown v. Google case, as well, obviously, your expertise around data transfers and what Schrems II means for our enterprise customers and enterprises out there in the ether. So thank you again. I would like to remind our audience to please subscribe to Big Ideas on the Go, wherever you download and listen to podcasts. Give us a recommendation, and thank you again for listening. And hope to see you, hear you in the future. Thank you again.
Thank you so much for having me.